Good morning. Happy Thursday. Today's the last day of the work week for me. Tomorrow, I get to sit in a day-long mandatory continuing education class so they could teach me how to be a lawyer, attorney, whatever. I don't know if we're still playing the definitions game. Speaking of the definitions game, as a practical advice to you, it's not really worth playing the definitions game as an argument or as a choice of arguments or as a fertile field of debate in YouTube comments. If each side has a definition that matches their use of the word, telling someone, I mean like an actual legit definition, not a D. Cup Jones definition, but like a legitimate definition. Like if you have a source, like if Merriam-Webster says this word means X, that would be really realistic. Let's say Merriam-Webster says this word means X, Y, and Z. And dictionary.com says the word means Y and Z. And you have a person saying the word means X, the other person saying knowing it doesn't, and then each side throws up their favorite link to their favorite dictionary. Well, at that point, the person who says it means X has actually won. You don't have to have all the definitions saying what you think it is. You just need one. You just need one. However, internally speaking, to be internally consistent, if you accept a definition out of a dictionary for a word, and then you should use that same dictionary to determine what they meant by those words. Say, for example, the word learned. This is coming up because my favorite sovereign citizen, my least insane sovereign citizen, to truth for liberty or to liberty for truth or whatever the hell, has asked me who they is about learned, because he seems to think that D. Cup's argument makes sense, that simply having studied the law in D. Cup's asinine fashion and inept fashion for 40 years, as D. Cup claims with no results, has somehow qualified D. Cup to be a lawyer because of the definitions of the word, and I don't believe so. The definitions, both definitions that I used, said, obviously, one said a person with a Juris Doctorate. Another one said, the court case cited Black's Law 6th edition and said a person learned in the law. Learned. And I stated that they don't consider what D. Cup is doing and what sovereign citizens to do to make you learned. You're not learned. I'm studying law in my own time doesn't make you learned. You don't become learned from that. You then ask, who is they? And why couldn't someone who doesn't have a Juris Doctorate be a lawyer? And I said, I said, actually, somebody who's done an apprenticeship may be considered a lawyer. I would give that to him because California seems to think so, and I'm sure other states do as well. If California does, I'm sure there are other states who allow apprenticeships to qualify you to sit for the bar, which would make you learned. But he wants to know who they is. And he himself used the Black's Law Dictionary, 6th edition. And so if you look at Black's Law Dictionary, 6th edition, and you look up learned, well, I'll let you do that for yourself. You have to be educated in the law. You have to be educated. It's not, I studied it, you have to be educated in it. You have to have like a degree. Anyway, but debating definitions is generally useless. It's not good fodder. Speaking of two truths for liberty, here's an interesting little debate, or at least I found it interesting. This is a classic example of moving the goalposts. Step number one, he claims that the Sixth Amendment guarantees you a right to counsel, and that right to counsel doesn't have to be an attorney or a lawyer, however you want to play this game. I said it absolutely does. Cite one case where the Sixth Amendment doesn't allow you, or doesn't require that you be represented by an attorney. Where you could just pick like your bartender to represent you or something like that. And then I, in addition to requesting him to cite a case, cited a Supreme Court case which states that you need to be a lawyer, that it needs to be a lawyer. The counsel is a lawyer. You don't have the right to a non-lawyer for your attorney. Doesn't necessarily have to be a bar member, just has to be someone who's accredited in the state, by the state, someone who's licensed to practice in the state. And that makes sense because the Sixth Amendment actually guarantees your right to counsel is actually a right to, yes, oh, you lost your stick, he lost his stick. It actually guarantees you the right to effective counsel. And that's, of course, to protect you from the state just giving you some shitheel attorney as your public defender who is not an effective counselor for you. So he came back with, instead of actually posting a case, citing a case that supports his decision, he came back with, well, number one, that's dicta. Okay, but he still hasn't, I mean, even assuming arguendo that Supreme Court case stating specifically that it has to be a licensed attorney, a licensed practitioner to be effective, to be assistance of counsel. Even assuming that to be true, he still has not provided the case stating otherwise. And number two, there was a number two. Oh, number two, he said that it was criminal, and he wasn't talking about criminal. Okay, well, the Sixth Amendment applies solely to criminal trials, to criminal prosecutions, criminal proceedings. That's all it applies to. It says it right there in the Sixth Amendment. Oh, no, he says, I was talking about the Seventh Amendment. So already, any disagreement I had with him could have been resolved had he said the Seventh Amendment in the first place. And now he's gloating to himself thinking, haha, I won this. But no, he did not. Because here's where we continue. The Seventh Amendment says that in civil actions, congratulations, exceeding $20, in federal civil actions exceeding the amount of $20, you have the right to a jury. It does not give you the right to assistance of counsel. And he still has not provided the citation to a case that says you do. Now, I'm going to say, then he switched it, I should say. So had he dropped it at that point and said, you're right, we would have been good. But then he switched it again. Now he's talking about guardians. If you're incapacitated, he says, or for your child, you have a constitutional right to effective counsel, and that can be you. You could be, if the guardian, your guardian can do it, your friend. And the answer to that is maybe. It depends on state law. The state may allow a guardian ad litem, a parent, somebody who's responsible for a person who is legally not competent they may allow that person to bring a suit. The Congress may allow for that person to bring a suit. But there is no constitutional requirement that they allow a guardian to actually litigate while you have the right to represent yourself, you don't have the right to it's not a right that a guardian could represent you in court in a legal fashion. They can make legal decisions for you, like whether or not to sue, maybe. I mean, depending on the statutes or the state constitution or whatever. They would get to make any determinations about settlement offers and things like that, but they wouldn't actually get to determine trial strategy. They wouldn't get to make arguments. They wouldn't get to do all those other fun things unless the state allows for it, or the enabling statute from Congress allows for it. It's just not a thing. And that is a classic example of moving the goalposts. Now, my particular strategy in dealing with someone who is moving the goalposts that hard is to eventually give up, because you've shown quite clearly what they're doing. Make argument number one, refute it. Make argument number two, if it's right, move along. If it's not, refute it. Where a lot of people get sucked in, where the trap is that eventually, if you keep going long enough, the goalpost shifter will move the goalposts, or will shift their argument. It's not really moving the goalposts, I don't know what it is, but they'll eventually shift their argument around to something that is actually correct. And since you've been telling them no the whole time, and you've been arguing with them the whole time, your instinct is going to be to stick to it and tell them they're wrong this time. And then they can say, ha, I got you. And they can present a case on their whole brand new opinion that matches what they're claiming, and then you look like an asshole. So a big part of arguing on the internet is, number one, don't play stupid dictionary games. If your argument revolves around citing definitions, that's pretty silly. Have you done that, John? Yes, I've done that. Does that make me a hypocrite? Well, these are traps everybody can fall into. I'm sure I've made multiple fallacious arguments in my life, and thank you for all the researchers out there who are doing their best to uncover examples of arguments from authority and things like that. I still don't think that was an argument from authority. I'm actually thinking it was a good argument because I won it, but hey, who knows? But yeah, those are a couple pitfalls that I just like to make people aware of. And you're wondering, why aren't you talking about auditing things? And at this point, I go through ebbs and flows in my interest in watching auditors. And it gets boring saying, yeah, this person trespassed. Obviously, this is stupid. Yeah, this person is breaking this law. It's apparent that they're doing it. Yeah, that wasn't a tyrant. That was an officer just doing his job. He had reasonable suspicion. He had probable cause, etc., etc., etc. That gets a little tiresome. It's a little boring. It gets a little repetitive for me. So I changed the topic today a little bit. And drama is a little too. I mean, how many times can you really point out the hypocrisy of Ben? Not talking about the hypocrisy of Ben. There was a news article that Nasty wanted me to bring to everybody's attention in the Daily Beast, because he's mentioned in it. And yeah, he's mentioned in it. Warden's mentioned by David, because that's what he likes to go by, don't you know? And News Now California and Mexican Padilla. It's not a very flattering article. It says what we've been saying all along. They're motivated by money, clicks, views, money. That's the thrust of the article. They're baiting cops. That's the thrust of the article. It's not very sympathetic. It's not sympathetic to the auditors. Although News Now California wishes he could get out of it. But you know, he just needs to make enough money doing something else that he can get out of the auditing game. Congratulations, Phil. You're my hero. Anyway. So yeah, that article isn't brand new or anything. It's been out for a minute. We're not garnering a lot of public support or public sympathy. I just hope everybody knows that we're not making a change. We're not protecting people's rights. We're not advancing people's rights. And yeah, it's just pretty. It's somewhat disheartening at times. How many auditors go to jail, get arrested, go to jail, get convicted every year? How many times have officers had to pay settlements every year? It's not a win. It's not a win situation. Yay, we got Turner v. Driver, but Turner v. Driver again was one of the 6 or 7 Court of Appeals cases that held the exact same thing. It didn't change anything. It just made that particular protection crystal clear. And if you're thinking, oh, it takes away officer qualified immunity, well, how many times have we pierced it in Texas since? I mean, congratulations, an attorney, or I guess an attorney too, but plaintiff, an auditor will be able to sue for more money. Yay, they'll be able to actually sue the officer. Congratulations. The auditor will get more money. And okay. I mean, people think that monetary incentives work, but you know, people still get in crashes every day. People still speed every day, and there's monetary incentives to not speed. So there you go. I'm a Debbie Downer. But hey, today I get to go to the Bay Area to file a response to a ex parte. So that's going to be fun. I'm thinking I might have me some lunch at Val's Burgers in Hayward on the way back, because those are damn fine burgers. And hopefully get back to the office in time to work another 3 or 4 hours, because that's what I do. Anyway, thanks for watching. Good luck in your internet comment battles. Remember, as long as they don't get to you and make you upset, you haven't lost. You only lose once they get you upset. Thanks for watching. Have a great day.